Okay, welcome everybody at the workshop General Terms and Conditions. Last year we expanded our network of supporting partners a lot, which are now 8, and Poelmann van den Broek is one of them. And these are all supporting partners that have a significant expertise for startups, I think, in order to grow in the right way, from valuation to general terms to how to get subsidies, sometimes also interesting, etc., etc. And so today we are talking about general terms and conditions. Maybe it's good to do a short round to get everybody introduced. And after that, we'll start the workshop. Shall I start on this side? Okay.
Yeah, I don't know. Yeah. Hi. Yes. Okay. I'm Beate Stevens, and I'm from Aerocount, a small startup company.
Christian Brunster, the founder and director of HCM Medical. We have a GMP license, ISO 3485, and we make medical implants out of biomaterials. 7 years ago, I started it. Now we see that we are being approached by multinationals, and there you always sit against a group of attorneys. So see what I can learn today.
My name is Koen Degeling. I'm a founder and CEO of TropicQ Health Sciences. We work on vector-borne diseases, diseases that are carried from one organism to the other by another organism, like mosquitoes and ticks. And so we were established 10 years ago. We are a CRO. We provide fee for service. We have contracts, but every now and then we sell a service just on basis of a quotation that we issue, and then it's accepted by the customer. And we don't have general terms and conditions. So I thought after 10 years, maybe we should change that.
It goes all right?
Yeah. So doing well.
Hans van het Klooster, CEO and co-founder van Pharmaceutics. We keep ourselves busy making drugs, pharmaceutical company. We keep ourselves busy making drugs look like food. So we attach chemically a food moiety to the active ingredient so that the intestinal wall recognizes it as food and picks it up.
Hi, I'm Jared. I'm from Australia originally. I'm a researcher at the Dundas Institute. I'm a neuroscientist. I'm in the process of founding a BV, a startup based on dream engineering and dream hacking for therapeutic purposes.
Robin Roodhuizen. I'm a counsel and for legal and commercial affairs, mostly in cooperation with OSNL for startups, and having a master in law and a lot of experience with these type of contracts. I hope that you can fresh up my knowledge a bit again.
I'm Tim Schroeder. I'm CTO and co-founder of 3D Neuro. We make brain implants for rodent basic research. We do have terms and conditions that we wrote together a couple of years ago when we started, but yeah, here to see if we find some tricks or things that we should put in or something that we should not have put in.
Hi, I'm Thomas. I'm a founder and CEO of ADEM, which is a spin-off from the Radboud UMC, but we started 1st of October. Not started really because I'm the only one in the team at the moment, but we are indeed starting up, and with ADEM we want to bring medical imaging to the first line, mainly focusing on ultrasound imaging.
Hi everyone, I'm Ksenia. I'm co-founder and CEO of startup Cardioma. We are alumni of Rockstart program, and also we are partner of Health Valley, and our company, we are developing medical device, wearable and service for remote cardiac monitoring.
Thank you. Yeah, and my name is Martin Kriens, program manager for Briskr. Okay, so I think this is the moment I give the floor to you.
Thank you, Martijn. Good afternoon, everyone. I will first introduce myself. I'm Valerie Lipman. I'm an attorney at law at Poelmann van den Broek since 2012. My specialization is commercial contracts, like distribution agreements, non-disclosure agreements, purchase and sale agreements, and of course, general terms and conditions, one of today's topics. Furthermore, IT and intellectual property law. So we review such agreements, we draft agreements, we can advise in negotiations. But of course, sometimes things can also go wrong in a partnership. In that case, we advise on termination, or for example, on compensation. And if necessary, we can initiate proceedings. Well, furthermore, I often advise about intellectual property law, like trademarks, copyright, and trade names. I do that together with Joost.
Hello everyone, nice to meet you. My name is Joost van Dongen. I'm an attorney at law at Poelmann van den Broek advocaten. I'm in the same team as Valerie and I advise on commercial contracts as well, IT law, intellectual property law, and then mostly soft IP law. So that's trademarks, domain names and such topics. The companies we advise are mainly mid to large size firms, also a few really large international firms. And we try to focus primarily on these three topics, and that's the main thing that we do. Valerie and I also often litigate in court as well, and primarily about these topics.
Well, about our firm, we are a law firm in Nijmegen with more than 70 employees, of which at the moment, goes to the next slide already, of which 32 lawyers at the moment. We mostly advise companies, as Joost just told you, as well regionally, nationally as internationally. Our lawyers are specialized in various fields of law, and we focus mainly on three types of industry. That's retail, production and tech, and construction law and real estate. Fun fact, we existed 45 years last year, party still to follow. And we handled over 75,000 cases throughout the years. Here you can see our expertise. We basically have all the expertise that an entrepreneur may have questions about. So you can see corporate M&A, environment and government, finance, banking, restructuring and insolvency. So a company can get to our firm for all these types of questions. Well, this afternoon we're going to talk about contracts in general terms and conditions. First of all, Joost and I will tell you something, and the second part of the afternoon we will continue with a quiz, and there's of course also a prize to win. We will touch on some topics that you often see in contracts or general terms and conditions, and give you some tips on what to look out for. We could, of course, talk about this topic all day, or perhaps even longer, but we've selected a few topics that we see a lot in our practice. Of course, feel free to ask any questions you might have in between. We would like to make it an interactive afternoon and try to give you as many examples as possible. One more thing, you will receive our sheets afterwards, so you don't have to write anything down, or not everything at least. One side note, we discuss general terms and conditions in business-to-business relationships. Certain mandatory rules apply when trading with consumers. We will not get into that today, but if you have any questions about that, we can get into it, of course. Joost will first start with the question, what is an agreement? Oh, here, the program for this afternoon. So we start with the presentation, then we will have a short break, and after the break we will continue with the quiz.
Okay, what is an agreement? It's quite a basic question, but a very relevant question as well, because there are a lot of discussions that can be done about this topic, even before a judge. Let's go to the first slide. According to the Dutch civil law, an agreement or contract is a multi-sided legal act, whereby one or more parties enter into an obligation towards one or more others. This means that an agreement has to be consisting of two parties at least, but can be more, of course. You can have as many parties as you want. It gets then a little bit complicated, but it is of course possible. But mainly an agreement is between two parties. If there's only one party, what will it be then? Any idea how you could call it? If there's only one party, there's of course probably not an agreement. How would you identify such legal document? Difficult question, the first one. Then you could qualify it as a statement or a disclaimer. A privacy statement is one party only. Most of the time, the firm who has a privacy statement that it's applying towards its visitors on the website. So that's one-sided. And most of the time, you don't have the acceptance of the other party when it comes to a disclaimer or a privacy statement. It's just a statement. That's it. An agreement is made through offer and acceptance. The offer is done by one party and is the declaration or intent or to include a contract. The acceptance is the declaration or intent to accept the agreement as presented in the offer. Well, it sounds simple, relatively simple, but it's not always clear if there has been made an offer or if the offer has been accepted. That's because of the fact that an offer or acceptance can be done orally. It can be done in writing. You can send an email with an offer. You can ask someone, hey, would you like to buy 10,000 pieces of this medical advice? It's an offer, but it can also be a conduct, dus door gebruik. And that makes it difficult because then it's hard to tell if an agreement has been made and if parties accepted the offer. So, and it's even that difficult that sometimes a judge has to rule about the fact if an agreement has been made between parties. So it's very important to make that clear. Well, here are some examples, quite straightforward to start with. First of all, the first example is just a regular purchase agreement, koopovereenkomst. A pays B 10,000 euros. In return, B delivers a 3D printer for creating prototypes. This is called a purchase agreement. According to Dutch law, a purchase agreement is defined in the law. So it means it has certain provisions that are applicable on the agreement. That's important because sometimes agreements are not defined by law, and then those provisions are not directly applicable on such agreement. The second one, A and B want to enter into a cooperation to sign a mutual non-disclosure agreement to protect the confidentiality of information shared between them. Also an agreement, but a different one than the first, but we can identify it as an agreement as well. The third one, A develops software and has copyright on the software. And I think this is important for everyone here because I think a lot of you are dealing with copyrights, not only on software, but maybe on other things as well. A develops software and has copyright on the software. A wants to transfer the copyright to B. A and B sign an agreement to transfer the copyright on the software from A to B. Okay, well, these were a few examples. Like Valerie already told in the introduction, there are also other examples for agreements like distribution agreements, agency agreements, franchise agreements, you can name it. And some are defined in the Dutch Civil Code and some are not. Agreements are most of the time mutual. That means that both parties have to commit to something. Does anyone know an agreement that doesn't create a mutual commitment? It's not on the slide, but yeah, that could be yeah, it's a good example. I was thinking about a donation agreement, so, an agreement to donate a certain amount to the other party. The other party only has to receive. So yeah, it's just a commitment for one party, but it's still an agreement. Intention agreement. It's mutual, but it doesn't create direct commitments to the parties. it can, but it doesn't create a commitment to enter in an agreement afterwards. Sometimes, maybe, but most of the times not. Few starting points when we're talking about agreements. The first one, it's a very old one, comes from the Latin time, pacta sunt servanda. Parties are in principle bound by what they have agreed. They have to respect the agreement. Everything outside the agreement is in principle not relevant. What's in the agreement is binding between the parties. Another one, freedom of contract. That means that you can contract about almost anything you want. And you can make it as crazy as you want, but there are some limitations. Does anyone know, can anyone think about a limitation and why you can't agree or make an agreement on almost everything? There's law, correct. and there's certain law, but the law is still a bit vague about that topic. But when agreements are creating an immoral or unethical effect, they are non-binding. For example, maybe, do you know an example what could be an immoral agreement? It was hard for me as well to make to make an example, but I made one. Now my example was A sells a knife to B. Well, A clearly knows that B is going to hurt someone with the knife. Well, that agreement is of course immoral, unethical, so not binding from the start. In Dutch we call it nietig. So that's an example. An agreement to kill someone, it's a bit more obvious. Agreements can be made in any form, and that's handy, but can also be tricky. You can do them in writing, you can do them orally, or they exist because of conduct, door gebruik. Some agreements are bound by written form. Does anyone know what I'm talking about? What kind of agreement is only binding when we are doing it in a written form? Some of you have made such agreements. You don't do it often. Yeah, correctly. When you buy a house.
Yeah, that's one example indeed. And if you want to transfer intellectual property rights, copyrights, then you also should do that written.
Yeah, and if you don't do it, it's void. So it's important to do it in writing. Otherwise, it's according to Dutch law, it's nothing. And last, relativity. In principle, an agreement only creates obligations between the parties. If I go into an agreement with Valerie, I can only demand fulfillment of the agreement from Valerie, not from Christian, for example. General points to watch out for when entering into an agreement. When entering into an agreement, make sure you have a signed copy. Well, that sounds strange because in the previous slide I noted that there's freedom of form. So maybe I made a mistake, but why is it important to have a signed copy? Of course, very important, you have proof. And it seems totally obvious and maybe a stupid question, but it's really important because Valerie and I see a lot of parties who enter into agreements about significant amounts, significant risks, and they don't put it in writing and it's not signed. And of course you can construct an agreement, but you want to avoid any discussion about the agreement. So it's very important when you make an agreement, make it in writing and make sure you have a signed copy for yourself.
Yeah, what we see very often is that parties are negotiating about a contract and they send it from one to the other by email and then they never get to a signed version. Well, yeah, then of course it's also the question, is that agreement binding or not?
Yeah, and we also... Yeah.
I think if the parties act upon that agreement, then it is a legal agreement, yeah.
But it can, of course, be an argument for the other party to say, well, I haven't signed it, prove that it's an agreement.
Yeah, say like provisions about price or something. Yeah, what is then the price that is agreed? One party could, of course, say, well, I didn't agree to the price, so must be another price. But most of the times, a judge will call it an agreement, yeah. It's both a hard copy and a PDF can be that as well. You can also electronically sign an agreement. That's better proof if you use a solid program for the electronic signature than if you just use a scanned PDF. But it will do as well.
Yeah, that's correct. You can use a digital signature, of course, to sign an agreement, but you have to make sure that it's linked to the person that signs the agreement. If there's doubt about it, it can cause an issue. The last one, if you enter into an agreement with a legal entity, or if you are representing a legal entity, I think all of you are most of the time representing the legal entity. It's important to check, first of all, for yourself, if you are authorized to represent the entity by yourself. There can be statutory restrictions, other restrictions that you have to look out for. The other way around, also very important, you have to check whether the other party is also legally represented. When we're talking about legal representation about yourself or for the company, if that's not done right, if you're contracting outside your authority, then it could, worst case scenario, cause that you're private liable for the agreement. So you have to fulfill the agreement by person. The other way around, if Valerie is contracting for Poelmann van den Broek, but she is not authorized to do so, and I do not check if she is authorized, it can become an issue for me to demand fulfillment of that agreement. Yeah. You can check it in the Chamber of Commerce. You can always see in the Chamber of Commerce who is part of the board of directors. So you can check it. You can also check who is wat is vertegenwoordigingsbevoegd? Yeah, who can represent the company outside the board of directors. According to Dutch law, the board of directors automatically are able to represent, but there are some restrictions in the statutories, so you have to check them as well. Sometimes, if it's a really big agreement about a lot of money, it's advisable to check the statutory restrictions as well for the directors. That's difficult. Then hoe doen we dat normaal?
Yeah, if you really want to check that, you should ask that party to send some proof that the person is authorized to represent the company. But yeah, of course, mostly you want for example, the director to sign the agreement, but that's not always necessary, because I can also sign some things on behalf of Poelmann van den Broek, because it is part of my job description. It's same like, for example, at the Albert Heijn, at the checkout, a person there can get into an agreement on behalf of Albert Heijn, just because of his or her job.
Yeah, and you can't find them in the Chamber of Commerce, of course.
Yeah. Yeah, indeed. Yeah. We often see that in a contract that it states that this person is legally authorized to sign this agreement, but that does not really do anything. Still the question if he or she is indeed authorized or not. Yeah.
Yeah, what sometimes helps is to make Dutch law applicable to the agreement. So if there's some issues about the agreement, you have at least Dutch law and the Dutch judge. That's also something you have to remind yourself of. That could say something about that agreement. Yeah, I know. Yeah, that's difficult, and especially when you're the smaller company. Yeah, I know. It's a hard negotiation sometimes. Yeah.
Well, maybe about the point in the middle on the previous sheet. It states it's advisable to add initials to each individual page. Might sound a little bit, maybe too much to do that, but we saw proceedings where the middle pages of the agreement were suddenly changed by one party. And then you get a discussion about that. So that's why it's advisable to put your initials on every page. Mm-hmm. Yeah, to be most safe, you should make 2 copies.
Yeah.
Yeah.
You make them in twofold and sign both. Yeah.
Yeah.
It depends on which law is applicable on the agreement. I know for Chinese law, for example, you have to have a stamp. I'm not sure why, but you have to have a company stamp. In Dutch law, it doesn't really matter because even if it's not signed, it can be a binding agreement. But so according to Dutch law, it doesn't matter who signs first. Yeah, okay. Yeah, well, that's something to look out for as well. Stamps, company stamps.
Now you should, of course, check
on AliExpress. You can get them.
You should, of course, check if you're the second party to sign, if the copy that you receive is indeed the agreement you agreed on.
Yeah, you can, of course, wait, but sometimes you don't have the option to wait. You have to be the first one to sign. But indeed, what Valerie says, it can be helpful to be the second one. Okay, an example. A is a startup in medical devices and needs specialized parts which she buys from the manufacturer B. A and B negotiate about prices and quantities and create a draft agreement. Without signing the agreement, A orders 10,000 parts for €2 per part in January 2022 and the next batch in March 2022. B delivers the parts. Is the draft agreement applicable on the order by A? Yeah, correct. Yeah. So the answer is yes, the draft agreement will in many cases be seen as the agreement under which the products were delivered. If a judge should rule about the applicability, it's very plausible that provisions in the draft agreement will be declared applicable to the legal relationship between the parties. The draft agreement can therefore be invoked even if the agreement has not been signed by the parties. No. But is that relevant for the answer? Could be. Yeah, that's true. That's true. Okay, next topic, general terms and conditions. Okay, general terms and conditions make it possible to regulate in a cheap and efficient manner contracts which are often concluded in much the same way. Before we started, I heard that some of you have general terms and conditions and some have not. I heard you, why don't you have them? Yeah. And are then the okay. Sounds scary. Okay, and is the other party make their terms and conditions applicable to the agreement, or is there no general terms and conditions applicable at all. Yeah. Yeah. Okay. Okay. Yeah. Okay. Okay. Well, general terms and conditions, it's always advisable to have them. General terms and conditions are defined by Dutch law as well. So they have to meet certain criteria. I've written down a few. They have to be in writing. You can't make them orally. It's also difficult to make them orally because they're quite long most of the time. So that's difficult to do. They have to be intended to be applicable on more agreements than just one. They have to be general. And therefore you can't include terms which are core performances. What could be qualified as a core performance? Yeah, correct. Very good. Price. You don't want to add price in the general terms and conditions. You want to add them in the main agreement. Valerie already stated in the beginning, general terms and conditions are legally defined in Dutch Civil Code, but you have to be extra cautious when you are dealing with consumers. Consumers are seen as a weaker party according to Dutch law. So it's important that when you are doing business with consumers, you don't use your B2B general terms and conditions, because most of the times provisions in the B2B terms and conditions are not applicable for consumers. Few questions about general terms and conditions. Are general terms and conditions mandatory? What would you say? Yes or no? No, I had a no. No. In principle, not. They're not mandatory. They're handy to have, but not mandatory. However, they can be made mandatory if you're part of a trade organization or if you are producing under a certain quality mark or certification. Those organizations can demand that you use certain terms. So it's important to look out for if you're dealing with a trade association or a quality mark. Is it mandatory to place your general terms and conditions on your website? Yes? And why? Yeah, why do you think it's yes? You have the gut feeling it's yes. Well, the answer is no. It's not mandatory, but for some website it is. So it's partly true. If you are providing products or services directly from your website, it's mandatory to make them available on your website. So e-commerce websites, or if you can download products, software, you have to make them available on your website as well. Difference between general terms and conditions and delivery terms. Does anyone know the difference between these two? Or is there no difference? Mm-hmm. You're on my next slide. I will handle that in my next slide. It's a good question, Christian. Difference between general terms and conditions and delivery terms. Is there any difference? The answer is no difference. The term of how you define your general terms and conditions, it doesn't matter. You can make it every name you want, as long as they qualify according to Dutch law as general terms and conditions. They have to follow the rules according to the Dutch Civil Code. That depends on the hierarchy between the contract and the general terms and conditions.
In general, yes. But sometimes you see in an agreement a hierarchy between the different documents. So you, for example, see, well, the agreement goes before the general terms and conditions, and
And then the schedules, and then you get a whole hierarchy of documents. But indeed, and therefore it's very handy to add a hierarchy between if there are more documents involved in the agreement, to add a hierarchy between the documents, and to point out which document prevails above the other. Okay, now we're getting at Christian's part. How do general terms and conditions become part of the agreement? By being the whole object of offer and acceptance. So it's not required that the other party is familiar with the content of the terms and conditions. They have to be part of the offer, and they have to be accepted by the other party to make them applicable on the agreement. When are general terms and conditions applicable on an agreement? Well, a major misunderstanding is that it's sufficient to have general terms and conditions, or just to mention that you have them. Sometimes you see we are having general terms and conditions. You can find them on our website. That's of course not sufficient to make them applicable on an agreement. Referring to the website, like I said, is in most cases not sufficient as well. What is important to make them applicable? 2 steps: declare the terms and conditions applicable while making an offer. So not after the offer, but while making an offer. That's a huge difference. Otherwise, you're too late. And hand over your terms and conditions if you're making an offer by email. Then you can send them as an attachment, but you have to hand them over to make them applicable. Any questions about? It can help, but it's not mandatory. If you sign the main agreement and there is stated that the terms and conditions are applicable on that agreement, and you've provided them while doing the offer, then you're fine. Mm-hmm. Now, if the judge will try to understand what party's intentions was, so that would be the main thing. So it's not that the contract is invalid because "and" is missing. The judge will look at the whole agreement and the phase before it, and try to decide if he thinks an agreement has been made between the parties. Yeah. Last example for general terms and conditions. This one, I think, Valerie, you had it in an agreement, right? It was stated in an agreement from a client.
This is a provision in an agreement about which I have now proceedings in court. So it's a really interesting question. You can see the agreement stated, our general terms and conditions are enclosed with this agreement. By signing and initialing this paragraph of this agreement, you declare that you're familiar with both conditions and accept that only these general conditions apply. Well, that's interesting because the agreement was signed on the last page, but this specific provision in the agreement was not signed. So what does that mean for the applicability of the general terms and conditions? What do you think? Yes, I also tried that in depending proceedings, but I don't know the outcome yet. But I see a big risk here for my client that the general terms and conditions will be applicable because they were added to the agreement and the agreement itself was signed. They were sent together with the agreement by email to the client. So I think it would be really difficult to state that the general conditions do not apply, but I hope so. No, they knew. Yeah, exactly. Yeah, it's a bit strange to add such a provision to your agreement, because if you do it, this makes it pretty much unclear of whether the terms and conditions do or do not apply.
Yeah, so the advice would be just to remove such provision, right?
Yeah, exactly.
Yeah.
But I will let you know the outcome. Okay, I will continue with something more about term and termination. Term and termination, this is a topic that we very often see discussed between contracting parties. May seem very easy at first glance, but in practice it's often different. I will show you some examples of that in a moment. First of all, it's important to distinguish between fixed term and open-ended agreements. Do you maybe know the difference? When is an agreement a fixed term agreement and when is it an open-ended agreement? Yeah, exactly. Yeah, fixed term contract is a contract entered in for a certain duration, for example, for a period of 2 years. But it may also be an agreement for example, the delivery of one machine. And after the machine has been delivered, well, the agreement is in principle finished. In case of an open-ended contract, the parties agree on a starting date, but not on an end date. An agreement that is entered in for a definite period of time will end automatically unless parties agreed upon auto-renewal. For example, you often see that a contract is automatically extended by 1 year. And an agreement which is entered into for an indefinite period of time will not end automatically. Well, the distinction between these two types of agreements may sound like a legal thing, and well, yeah, it is, because the distinction is important for the question whether or not a contract can be ended. If no agreements are made about termination, then the main rule is that a contract for a definite period cannot be ended, and a contract for an indefinite period can be terminated. However, mostly a contract for an indefinite period can only be terminated if a reasonable notice period is observed. And in some cases, it might also be the case that termination is only possible if there's a compelling reason to do so. One might think of the situation where one party, at the request of the other party, has invested heavily in the cooperation, and these investments have not yet been recouped. In cases parties have worked together for a very long period, or are, for example, highly dependent on one another, it's more likely that a compensation has to be paid or that a longer notice period should be observed. Will not be soon that an agreement cannot be terminated because of serious grounds. Well, whether or not a contract can be terminated can often lead to discussion. In view of this, it's advisable to include a provision about term and about termination possibilities in an agreement or in general terms and conditions. But in that case, if you do, make sure that the text of the provision is clear. I will now show you some examples of how not to do it. Here again, I have a provision from an agreement from one of our clients.
Yes, correct.
That Joost has now a case about it. It's interesting to read this provision. First of all, you see, this agreement shall become effective from the 1st of January 2021 till the 31st of December 2023. So, this is an agreement for a definite period of 3 years that in principle cannot be ended prematurely. Agree? But then we read on and we see this agreement can be terminated by any party taking into account a notice period of 4 months. So we can terminate the agreement early, but only with a notice period of 4 months. But then if we read the last sentence, it states, in case neither party terminates this agreement 4 months before the end date, the agreement will automatically be renewed for the duration of 1 year. So the question is, can this agreement be terminated now, or can it only be terminated on 31st of December 2023 if notice is given before the 1st of September? What do you think?
That's not in the interest of my client. Your approach.
Yeah, this provision is totally unclear. We had a lot of discussion about it in the office.
Hours.
And
yeah. Yeah, they explain it differently. One party wants to terminate the agreement, and they terminated it in what was it, April 2021. They said, okay, we want to terminate the agreement as of March 2022. So with quite some time between it. And my client, who is in the business of creating young plants, and made really large investments in the nursery. They don't want to that agreement ends because they want to return their investments, and so they state it is an agreement for a fixed time, and that can be terminated. And the 4 months period only sees to end the renewal, but not. So they have a different perspective. It's a German party and a Dutch party, but it's according to Dutch law, so that helps a bit. But yeah.
yeah.
Mm-hmm. Okay. Mm-hmm.
Yeah, that would be a good thing to do, but they didn't. Yeah.
They're doing business for over 20 years. I hope so, yeah. We're not yet at the court. I'm just drafting my my last letter to the counterparty. So I don't think they even read it at all. I think that's the problem. Yeah, and it. Yeah. You're doing business on trust and conduct, and but my client invested for over 2 million in his nursery, and now the agreement may end. So it's a problem. I don't know. No, I do know. It's a contract from the other party. Yeah. Yeah.
Yeah. Well, basically, we think because of the last sentence that the 4-month notice period is just meant to prevent the agreement from tacitly renewal.
Yeah.
I have another example here. Contract starting date 1st of July 2014. Period is 12 months. Thereafter is tacitly renewed for the same period, unless notice is given. And the term of notice is 3 months. Well, has this agreement always been extended with 12 months or only just once? And when can this agreement be terminated? It's also not completely clear. Also from one of our cases. What would you say? Yeah.
Mm-hmm.
Yeah, that's right, indeed. Yeah. This was just a commercial agreement for a container, indeed, garbage.
Garbage contract.
Well, I think you could say here that the agreement will be renewed for 12 months and then again for 12 months and again for 12 months. But you could also argue that is extended once with 12 months and that after that an agreement existed for an indefinite period of time. You can say that was the other party was stating that the agreement was only renewed once with 12 months. And after that, there was no fixed term anymore. So even if you think it is clear, then it can sometimes lead to discussions. Yeah, I think that's an argument to state that it's each time renewed with 12 months. Yeah, I agree. Let's see. No, well, when entering into an agreement, you always have to ask yourself, do I want to be able to walk away from this agreement? Or do I, for example, want my contracting party to be bound for a longer period of time? I have another interesting example of this, not on the sheet, but in December, a client of ours had an agreement concluded with a software supplier for the duration of 2 years. It was a contract for the supply of software for a client's critical system. So the software was fully integrated into the client's other systems, and our client made substantial investments in this. It was an agreement for duration of 2 years, and you guess it, at some point the supplier announces that the software will no longer be delivered as of the 1st of January. So in December, the supplier said, well, 1st of January, you can no longer use the software. What's the position of our client here, do you think? What can our client do? It's an agreement for 2 years. Yeah, from a contractual point of view, our client had no chance in this case, because a fixed term contract had been concluded for a period of 2 years, and the 2-year period was over. So therefore, the agreement automatically ended. However, in the end, by appealing to the IT supplier's duty of care, we managed to arrange that the supplier would continue delivery for 2 months more. But the duty of care is really an exception. So our client was really lucky with this outcome, because contractually, he had really no chance. So this is again an example. If you buy something that you think you need for a really long period, then it's better to conclude a contract for a longer period of time, or of course to conclude a contract for an indefinite period and then just include a really long notice period. Because of course you can also say, well, it's a contract for an indefinite period of time, but it can only be ended with a notice period of 1 year. And then you would have sufficient time to go to another supplier. In this case, our client had almost no time, because before they could get other software, it would take months. So that was really a problem. And then the complete system could not be used anymore. Yeah, good question. It was a really large software company, and they just said, yeah, well, we have a new product and it's very expensive for us to keep delivering this old product, and you're the only client of ours, so we don't want to use the servers for that software anymore.
Yeah, and there were licenses involved as well, right? So they stated that we have to renew the license for the software as well, only for you, and that's too expensive.
In this case, it was a bit strange because the supplier had just sold the software 2 years ago, and they knew that it was really important for our client. So I stated, yeah, well, you should never have had advised that software in the beginning, because you already knew that you were not going to deliver it for a long term, while our client needed it for a long term. And that was in the end a reason for the IT supplier to say, well, okay, we will continue 3 months longer so that you can find another supplier. But we had to start proceedings to get this done on a really short notice. Yeah.
Yeah, and it was a very expensive project as well, the software project.
Yeah, they invested like 1 million around. Yeah, exactly. Yeah. But it's always a bit of a gray area. And it feels like, yeah, the last redmiddel,
yeah,
the last thing you
last
can
resort.
do.
Yeah, of course.
Yeah. Yeah,
Right.
exactly. Yeah, and this client thought, well, this is an agreement for 2 years. And after that, I will agree to a new agreement of 2 years, and there's no problem at all. But didn't think that the IT supplier would stop supplying that specific software. So that was the problem. No, that was also an argument I used in the proceedings. Yeah. Mainly the last thing. Yeah. Well, they said we can supply another product, but that was way more expensive. So that was not that interesting for my client to use.
They didn't care if our client would leave or not. So they were not trying to make more out of it or something, which was really strange. But
they were just saying, well, the contract was for 2 years, so you should have known yourself that the contract could end. Yeah. All right. Any more questions about term or termination? Yep. Yeah. Yeah, like change of control. Mm-hmm. Yeah, that's really difficult. Best would be to define that as much as possible in the agreement, because if you don't, then you can state it's a competitor. But if the other party does not agree, then you will probably end up in court to discuss about it. Yeah. But it is valid. But it will also always have to be explained on what is meant with this specific provision. Yeah. Mm-hmm.
asking for a friend.
I think you can say that you're still bound by the terms of the contract. Yeah. Mm-hmm. Yeah, the question is, of course, always, is it a fatal term for the delivery? To say it must be delivered before this or that date. And then the counterparty could say, well, you didn't live up to your obligations, so I will end this agreement. That could be the case. Yeah. Okay. Yeah. Overmacht, yeah, force majeure. You see that a lot in relation to Corona. Well, maybe in the first months of 2020, you could say that, but that will not work any longer, I guess, because we're in this situation for so long that companies should now
have to deal with it.
Yeah. Do you need a break already, or can we move on? Okay. Then we'll move on to liability. But provisions limiting liability of parties often receive the most attention in a contract or in general terms and conditions. We see that in practice. Parties often try to limit their liability as far as possible. What is important to know is that a complete exclusion of liability is not possible according to Dutch law. Liabilities for damages resulting from intent or deliberate recklessness cannot be excluded. However, liability can be severely limited. As with termination, it is important to determine what you want to achieve with the agreement. In case of an agreement between, for example, a supplier and a buyer, the buyer is particularly exposed to risk of damage, which may be caused by the supplier's product. In this situation, the supplier will want to limit the liability as far as possible, while the buyer has an interest in retaining the liability of the supplier. So always look carefully what side you are on. Mm-hmm. Yeah. Mm-hmm. Yeah. Yeah. Mm-hmm. Yeah, they can say that. They can say that. Yeah. Mm. No, not in that case. No. The only exception is the intent or deliberate recklessness. So if a party does something wrong on intent or really recklessness, then liability cannot be excluded. In other cases, it can, to a really far extent in business-to-business relationships. Only when it comes to a consumer, so business to consumer, then there are some rules of law that make it more difficult to exclude your liability.
No, yeah, it has to be deliberate. So an accident can happen, of course, but you have to have the intention to do something to harm some company or anything. So no. Then it's another situation. But then you have to prove that they know it, and that can be difficult. That can be really difficult. But that could be an argument. Yeah, of course. Yeah.
Yeah.
Yeah. It's the same. Ja, ik denk dat het meer een.
I think it's kind of the same.
It's kind of the same yeah.
thing.
Same thing, different wording. Yeah, I know. Yeah. I would share it under gross negligence as well. Yeah. Yeah, it's similar. Yeah.
That's their liability. Yeah, so now they want
Yeah, that's exactly the problem when negotiating on this kind of clauses. Well, one party wants no liability and the other party wants complete liability. Yeah.
Like this.
Yeah, it is indeed complicated, but of course, for a small company, then that's a real risk, because if you are infringing, then well, the damages can be enormous.
Maybe insurance.
Yeah.
Yeah, but yeah. yeah, I know. Yeah.
No, you cannot really do anything. No, it's a real problem indeed.
Thanks.
Well, what you could do is to try to negotiate, but yeah, most of the times they will not. Yeah. No, and then. Mm-hmm. No, sometimes you see clauses that they will then deliver a new product that's not infringing, for example, but. No.
we can help.
No, I understand. No, it's really difficult indeed. Yeah. Well, you can make a distinction between different types of damages. Distinction is often made between direct and indirect damages. For example, a party delivers a machine that breaks down after 1 month. Machine can still be repaired, but will take 2 weeks. Well, then first of all, there's damage suffered because a new part has to be purchased to repair the machine, or you can ask the other party to repair the machine. And second of all, there's consequential damage. That's the damage suffered as a result of the non-functioning of the machine for 2 weeks, which could, of course, lead to loss of profit. Well, this distinction is seen often in provisions about liability. For example, here you see that neither party shall be liable to the other party for loss of profits, loss of opportunity, loss of revenue, consequential loss. So that means that you can claim if, for example, something is wrong with the product and you want it to be repaired, but you cannot claim lost profit. Well, that might be a way to create a fair and acceptable proposal. Depends, of course, on the risks, because sometimes you order a product that's really essential for your business. If you can go totally out of business, if there's something wrong with the product, well, then you would want the other party to be liable for consequential damages. So also here, you should always assess what are the risks and what side am I on. Well, some other possibilities that we often see, you can of course limit liability to a certain amount or to the amounts paid under the agreement. If you choose for the last version, then of course you should assess how much is paid under the agreement. Sometimes that's a really low amount, and sometimes that can be a high amount. And in the last case, yeah, well, you do not exclude your liability so much. Because then it would be better to go for the first option. Last example, you often see that liability is limited to the amount paid out by the insurer. In that case, most of the time you see a sort of safety net to also limit liability to a certain amount in case the insurer does not pay out. Any questions about liability? Yeah. Yeah, exactly. Yeah. Yeah, exactly. Yeah, we always see there's a lot of focus on the liability clauses, but most of the times there are some ways to work around it. And that's one example to do that. You can, for example, also state that if you are the party that has to deliver the machine, that you say, well, if something breaks down, you can only ask me to repair it, but you cannot claim damages. Or you keep the damages up, but yeah, you limit the actions that can be requested from you if a machine breaks down. Well, we have two more small topics, and then we can go to the break. One is intellectual property rights. I'm going to talk here about copyright, because copyrights can be automatically obtained by virtue of law. In principle, if you create a product, then the law states that you can get a copyright automatically. For example, this may concern photos, but also product packaging, text, layout of a website or source codes. There's no register for copyrights. And it's important to know that in principle, the copyright belongs to the creator. So the party that makes, for example, the product. A really common misconception is that the party who pays for the development gets the copyrights. Copyrights are always with the person who creates it. I have an example of that here. You see, Doodle is a startup developing software, and it commissioned NextGen to write software. Doodle pays a substantial sum of $500,000 of euros. And then the question is, who owns the copyrights to the software? Well, I just told you. In principle, it's NextGen coding, but parties can arrange that NextGen coding will transfer its copyrights to Doodle, but you will need a written agreement to do so. So here's the link to general terms and conditions and agreements. If, for example, new products are developed or software is brought onto the market, copyrights will play an important role. And in that case, if it's important for you to have the copyright yourself, then you must make sure that the copyright is transferred to you by a deed, so a written agreement. Any questions about IP? Indeed, yeah. Yeah. Basically, it's the last thing indeed. Yeah. Well, I stated here already that if copyright work is created during employment, then not the creator, but the employer becomes the copyright owner. Yeah, in some cases, it can also be the case that if you really gave instructions and the other party made the work conform the instructions, then it can also be the case that the copyright belongs to the person who gave the instructions. Yeah, but it's of course always difficult to prove. Well, maybe one more interesting thing is that well, copyrights can be transferred by deed, but if the other party does not want to do that, you can also get a license. That's also always interesting, also the other way around, because it can be an interesting business model. If you have copyrights yourself, you can give out licenses to different parties and then use that as a business model. Well, then something about confidentiality. In a collaboration between parties, confidential information is regularly exchanged. In that case, you naturally want to prevent this information from becoming public. The distribution of confidential information can be unlawful even without agreements being made. In that case, however, you have to demonstrate the damage you suffer as a result of the information being made public. In many cases, this is of course very difficult to prove, because what damage exactly do you suffer if company information becomes public? It's therefore advisable to conclude a non-disclosure agreement before parties start negotiating with each other about a possible agreement or business relationship. Well, the last thing says, if the counterparty does not want to sign an NDA, you will have to ask yourself whether this is a reliable business partner or not. After all, the only obligation that follows from the NDA is to keep the information a secret. One important thing regarding to NDAs is to define which information should be confidential, because that's not always completely clear. And it is important to include a fine in a non-disclosure agreement, because of the fact that the damages may be very difficult to demonstrate. And if your company information becomes public, you can claim the fine and you don't have to prove what damages are done. So that's a really easy way to recover some of your damages if this happens. Yeah, exactly. Yeah, most of the time you see an exception for that in agreements. So most of the times you see, well, the obligation is not applicable if the information was already known by the other party, or if the other party gets this information from another party, not violating the NDA. So there are always some exclusions on that. Yeah. Yeah. Mostly you see some exceptions that you can add. Yeah, good question. And the last thing is, yeah, most of the time you do not want the NDA to end, of course, because why should it be possible to make the information public after a certain time? well, therefore it's advisable to add something about the term. Mostly you see that the agreement does not end. But if you have an interest that, for example, after 5 years you can use the information, well, then you should include the term of 5 years. But mostly that's not the case. Yeah. Good question. Mostly you see in the NDA that the party that signs the NDA also has to make sure that, for example, employees stick to the non-disclosure. If they're no longer an employee, yeah, then the employer does not really have control over the employee anymore. However, I still think that the other party may be able to claim damages if the former employee does that. Yeah, exactly. Yeah, not for the employee, no. No. Yeah, it might be the case. That depends on whether or not the employer concluded an NDA with the employee. Sometimes you also see that. No, it's just the same, different term. Yeah, yeah.